a fun game that earns you money. How much did you guys make from CryptoZoo?
I lost around $50,000 in CryptoZoo.
I lost $40,000.
I lost around 15,000 US dollars.
I lost $25,000.
$120,000.
$500,000 Australian, which is $500,000 in CryptoZoo.
Shut up! No, you haven't!
Yeah, 500K.
Oh, no.
Good for you, but also you're slimy as f. We're gonna handle this ourselves while we continue to build CryptoZoo, and I'll see you in court.
Logan Paul spent millions of dollars on an inflated legal team to change the public narrative about his dealings with CryptoZoo, and for all that cash spent, nothing changed.
Logan Paul's CryptoZoo scheme duped many investors, and after Coffeezilla revealed the fraud, Logan responded with a lawsuit. For 2 years, he poured a fortune into legal battles, claiming defamation. From the start, the effort was doomed, as he tried to suppress his own deposition, was caught lying in court, and each month the case worsened his image. The outcome is less important than the process. Throughout the litigation, Logan and his team fought to keep his deposition secret. That deposition was simply Coffeezilla's lawyers questioning Logan under oath about CryptoZoo.
Logan Paul v. Coffeezilla defamation case, the two parties are currently fighting over whether Logan Paul can mark his entire deposition as confidential. And in the last couple of videos that I did on this topic, I talked about how this is actually highly unusual to ask for an entire deposition to be marked confidential. And I talked about how Logan Paul's arguments for why it should be marked confidential are actually really...
Logan Paul fought to seal his entire deposition from public view. This desperate move raises significant concerns regarding the damaging information hidden within those records. LegalBytes provided expert analysis of the case throughout these legal battles. The judge rejected all 4 arguments presented by the defense to suppress the footage. The first argument claimed that Coffeezilla would leak the material to the public or law enforcement, yet sharing evidence remains perfectly legal. A second point alleged that Coffeezilla provided documents to the FBI, which is a lawful act and not grounds for sealing. The defense further argued that Coffeezilla violated the spirit of a protective order, even though the order itself imposes no restrictions on sharing information. Finally, they claimed that providing materials to the lawyers handling the CryptoZoo class action was improper, ignoring the fact that parties are fully permitted to share non-confidential discovery.
As a root problem, he doesn't make any argument that anything in the deposition is sensitive or private in nature. In other words, he doesn't really make any real arguments as to why this entire deposition should be treated as confidential.
That is the fatal flaw. Across 4 distinct arguments, he never identifies what exactly requires protection.
So here we're talking about how I think that in Logan Paul's reply, his lawyers did some things that can potentially backfire. And explaining this really starts with the weakness of his arguments. Let me put it this way. There's this old trial lawyer's saying that if you're weak on the facts but strong on the law, pound the law. If you're weak on the law but strong on the facts, pound the facts. And if you're weak on both, pound the table. Pounding the table is often thought of as being like forceful or aggressive in your tactics, but I actually like to think of it as any strategy to try to essentially distract from the fact that there really isn't much to your case or your position in this particular argument. But the thing is, depending on your strategy here, you could find yourself in the danger zone with the judge. And I think that is where we just might be in this particular issue. To start, Logan Paul's reply is an opportunity to strengthen the arguments from his original motion. It's supposed to be pretty limited in that it's supposed to be responding to the opposition, but nevertheless, it should be able to use something to kind of bolster it somewhat. But instead of doing that, he basically repeats all of the arguments from his original motion, all of which, like I said, I think are already pretty.
Logan Paul chose to strike a table rather than addressing the legal facts at hand. His follow-up motion failed to add substance, merely rehashing points already dismantled by opposing counsel. This approach defined his broader strategy. Logan Paul leveraged his superior financial resources to drag the proceedings through endless delays, forcing Coffeezilla to exhaust time and capital just to maintain his position in the dispute. The legal filings diverted focus toward technicalities like sealing depositions and sharing discovery. These maneuvers ignored the central issue regarding whether his statements about CryptoZoo were misleading. Wealthy litigants frequently employ this tactic, but it typically undermines their own standing. A defendant fighting this aggressively to bury a deposition ultimately reveals they have something significant to hide.
Now, to make matters worse for Paul, his lawyers at one point in this reply tried to do that thing that I described earlier. You know, where both sides will take the legal authority that the other side is using to support their arguments and try to show how it actually supports our side. But the problem is, as much as Paul's lawyers are trying to do that, in my opinion, I think they're very unsuccessful at it. For example, in this part of the reply, they're responding to Coffeezilla's argument that in order to mark his deposition as confidential, Paul needs to show good cause. And this basically means that Logan Paul needs to have a good, rational reason that has something to do with some kind of privacy interest. It's really not all that hard to do, but the problem for Logan Paul is that nowhere in any of these filings does he ever argue that he has good cause for making any part of his deposition confidential, let alone the whole thing.
Securing a court order to seal records requires a legitimate justification based on privacy. The threshold is not particularly high, but necessitates concrete proof like sensitive medical data or financial specifics. Even then, courts generally prefer redaction over sealing entire files. Logan Paul claims the content is embarrassing, but that provides little weight in a legal setting. His legal team attempted to bolster this position by citing a past case, and the result was far from convincing.
Instead, Paul tries to suggest that the case law Coffeezilla is citing to says it's actually a more lenient standard than what Coffeezilla is arguing. Specifically, Paul says defendants' own authorities recognize that the standard for designating non-filed materials as confidential is, quote-unquote, more lenient. And then Paul cites to this case from the Fifth Circuit, Hoali v. Exeter Financial Corporation. But the thing is, although Paul says that there's like this more lenient standard, he doesn't exactly say what that more lenient standard actually is. And there's a very good reason for that. That's because if he did, it would naturally highlight the fact that the one thing that the Fifth Circuit says that Logan Paul needs in order to mark the deposition as confidential is good cause. Specifically, here's exactly what the Fifth Circuit says. In our view, courts should be ungenerous with their discretion to seal judicial records, which plays out in two legal standards relevant here. The first standard, requiring only good cause, applies to protective orders sealing documents produced in discovery. And then it goes on and actually says, under both standards, the working presumption is that judicial records should not be sealed. So reading that, the Fifth Circuit is actually pretty clear that Logan Paul's motion should absolutely fail.
They referenced a case that supports the opposite conclusion and deliberately avoided defining the lenient standard, knowing it would reveal a requirement Logan lacks. The Fifth Circuit maintains a presumption that records remain unsealed.
By the way, not only is this understanding of this issue pretty common across the board in the United States, but the Fifth Circuit is also binding authority on the court that we're in right now with this lawsuit. In other words, the judge in this case is required to follow this case law. And you know, I want to share a little bit more from this Fifth Circuit opinion because I think it beautifully illustrates why it's important for the public, you and me, to have access to this kind of information. For context, this case, Hoali v. Exeter Financial Corporation, involved two parties who basically agreed behind closed doors to keep like 3/4 of the discovery in that case marked confidential, and then to seal it permanently just so that the public could never have access to it after the litigation was over. And by all appearances, they didn't do this because this information was actually sensitive in any way. It's just the parties wanted to keep information private amongst themselves. And so the Fifth Circuit said in response to this, the public deserves better. The presumption of openness is law 101. The public's right of access to judicial records is a fundamental element of the rule of law. Openness is also civics 101. The Constitution's first 3 words make clear that ultimate sovereignty is wielded not by the government, but by the governed. And because we the people are not meant to be bystanders, the default expectation is transparency, that what happens in the halls of government happens in public view. Americans cannot keep a watchful eye either in capitals or in courthouses if they are wearing blindfolds. Providing public access to judicial records is the duty and responsibility of the judicial branch. Why is this important? Because accessibility enhances legitimacy, the assurance that things are on the level. Article 3 courts are independent, and it is particularly because they are independent that the access presumption is so vital. It gives the federal judiciary a measure of accountability, in turn giving the public confidence in the administration of justice. Put simply, protecting the public's right of access is important to maintaining the integrity and legitimacy of an independent judicial branch. And hopefully, more access to judicial records means more trust in judicial officers and more respect for judicial orders. Judicial records belong to the American people. They are public, not private documents. Certainly, some cases involve sensitive information that, if disclosed, could endanger lives or threaten national security. But increasingly, courts are sealing documents in run-of-the-mill cases where parties simply prefer to keep things under wraps. And so this opinion goes on. If you want to read more from it, which I highly recommend, I am linking to a copy of it in the description below. It's very passionate and very clear about how we shouldn't just be allowing parties to mark something as confidential simply because they want to keep it out of the public's eye. And oddly enough, that sounds like exactly what Logan Paul is trying to do here.
The judge must follow this precedent. Logan Paul has effectively built the argument for Coffeezilla by providing the evidence himself. It is ironic that he spends hundreds of thousands on legal fees only to strengthen the opposition. The core issue involves two parties privately agreeing to bury court records simply to suit their preferences. This sets a dangerous standard. If wealthy individuals could seal files at will, justice would only be transparent for those with less money. CryptoZoo was never a private matter, as thousands of investors suffered losses despite promises of refunds that never materialized. The public deserves to verify if those sworn statements match his previous public apologies. Discovery of a contradiction between his deposition and his videos would destroy his credibility. That is the actual motivation for keeping these documents secret. Logan Paul's lawyers eventually took a move that was genuinely risky.
So now that we see the weakness in Logan Paul's arguments here, I want to talk about the pounding on the table part. Specifically, here's where I want to talk about what Logan Paul's lawyers do that I think could end up backfiring. Now, there are actually a couple things that Logan Paul's lawyers do in this reply that the judge might not like, but I really want to focus on one of them. And basically, it looks to me like Paul's lawyers may have twisted the judge's words out of context in order to make their argument.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Let me explain. So remember how in his motion, Logan Paul pointed to something that he says the judge said at some point. Specifically, Paul says, plaintiff has reason to believe that Mr. Findeisen and his counsel have routinely been sharing discovery materials from this case with the class action plaintiff's counsel, something this court expressed concern about when it decided to temporarily stay this case, and conduct which, again, constitutes use of discovery materials for purposes other than litigating the claims and defenses in this action. So now when you read this, it sounds like back when the judge decided to temporarily freeze this case back in September, he had this super serious concern specifically about Coffeezilla sharing information with the class plaintiffs. But if you watched my first video on these arguments in this particular issue, you know that I looked back at the judge's September order staying the case, and I saw that the judge didn't say anything about this in that written order. And so in that video, I said, you know, the only thing that I can really think of is maybe the judge made some kind of a comment at the hearing just before this written order came out. And as it turns out, in the reply, we finally get to see that that's in fact where Logan Paul's lawyers are getting the idea that the court expressed this concern about the sharing of information. Specifically, Paul's lawyers attach a very small bit of transcript from this hearing to show this. It's really not enough to get full context on what exactly was being said, but we can basically put together more or less the main gist of it. And the thing is, now that I've seen at least this much of what the judge said here, based on how much I can put together, it kind of looks like Paul's lawyers.
The filing says the judge feared Coffeezilla might give discovery to the class action attorneys, yet the September order contains no such language. The sole support is a brief transcript excerpt lacking any context.
And if that's the case, that is a problem for them, because that would mean that they are twisting the judge's words to the judge. Let's take a closer look so you can know what I mean. So this hearing transcript that Paul attaches starts out where the judge is talking about Coffeezilla's earlier request to transfer the case from San Antonio to Austin so that it can be litigated in the same court as the class action case. And there's discussion leading up to this that we can't see, but he basically concludes that he doesn't want to transfer the case over there. So the judge says at the top of this page, so I'm wondering, I will tell the parties the motion to withdraw, the transfer to withdraw. I'm not transferring this case to Judge Griffin. It would not be fair. I've already had involvement in this case, he's got enough on his plate. But I am considering staying some or all of the proceedings in this case while that case gets rolling. I need to hear from the parties on it. I'm concerned about it. Judicial resources need to be economized. There is the danger of prejudice to both sides. I'm very concerned, even though there's a voluntary agreement by these potential class members to subject themselves to deposition, I'm concerned that that could be prejudicial to them. I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order. And the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? I'm worried. I do not want to prejudice the parties. I need to hear from the parties as to how to address these issues. It's separate from the motions in front of us. I'd like to start with the plaintiff. So it sounds like what the judge is really saying here is, we have these two cases where one person is a party in both of them, that's Logan Paul, and then you otherwise have other people who can be affected in one case by something in another case that they're not even involved in. And so rightly, the judge is worried that there are things that can happen here that could lead to an unfair prejudice to one or another side, and if these parties start to engage in discovery funny.
The danger lies in how they distort the judge's own statements, twisting his words back onto him. Even more troubling is the apology video he later released.
Coffeezilla is not a criminal. I called him, I apologize. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially you're gonna be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million. I'm sorry, guys. I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, Coffeezilla. You have catalyzed this, and I am very grateful for your work and your investigation, and I mean that. Thank you, bro.
Logan Paul, known for publicly saying one thing while doing another, apologized. He affirmed Coffeezilla was correct, thanked him, and committed 1,000 Ethereum for refunds. Yet the real offer soon arrived.
Logan Paul is refunding people he scammed if they promise to stop suing him for the vastly larger amount he may owe them. And honestly, I'm conflicted because on the one hand, victims getting money is always great. And I'm proud that our investigation led to some real-world consequences. But I can't pretend that things are fixed or fine for people who entrusted me with their story when that's just not true. So here's the real, more complicated story in 3 parts: the refund offer, the Zoo tokens, the lawsuit, starting with the most important part. And if you get one thing from this story, this should be it. These are the estimated damages in CryptoZoo, $18.5 million, which comes from a combination of ZooCoin and NFT sales. And then this, much smaller percentage of that pie, is what Logan is actually offering to refund, on the condition, though, that all of the people who spent the last year suing him for the larger damages drop their case. So that's a refund of only 12% to drop 100% of the case that, as far as I can tell, Logan may be losing.
Logan Paul offered a 12% refund on estimated damages, demanding a complete case dismissal. This revealed a stark hypocrisy. He had previously sought to move the lawsuit to San Antonio, ensuring information could cross between 2 cases. That decision benefited him then. Now, with the same information flow threatening to work against him, he panicked.
The reason this probably came up is because, remember, the judge started out here in this hearing transcript talking about Coffeezilla's motion to transfer the case. If we look back, in that motion, Coffeezilla made the argument that the whole reason Paul filed this lawsuit was to purposely engage in funny business. Specifically, one reason was to punish Coffeezilla, and then the other was to get around roadblocks that came up in the class action case and to gather discovery from Coffeezilla that he could use in the class action case and during a time when the class plaintiffs weren't able to collect any discovery against Paul. So with that in mind, when we look back at this hearing transcript that Logan Paul has attached to his reply, let's home in on one part specifically. The judge says, "I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order." What that means is the judge is actually recognizing that the protective order can't necessarily stop Coffeezilla from sharing non-confidential information with the class plaintiffs. And then, importantly, the judge immediately also says, and the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? Again, he's saying, how could he not use that in that case? That means he's once again acknowledging, I know I can't stop Logan Paul from using discovery over there after he gets it over here. And so what we can piece together is that the judge here isn't saying, hey, Coffeezilla, you're not allowed to share information with the class plaintiffs at all. And to be clear, that is actually what Logan Paul is trying to suggest in this current argument over his deposition. But rather, what it sounds like the judge is actually saying here is, I'm worried about all of this just turning into a huge mess where both sides start to abuse the discovery process across the board to get an unfair one-up on each other between these two cases.
The judge remained unimpressed by Coffeezilla and instead focused his scrutiny on Logan. The court expressed concern that Logan acts as a party in both legal matters, creating a risk that he might extract discovery from the defamation case to weaponize it against the CryptoZoo victims. These victims remain uninvolved in the current proceedings and possess no path to recovery, which led the judge to deny the transfer request. The court further deliberated on the necessity of pausing the litigation entirely.
And importantly, then the judge also says, okay, attorneys on both sides, give me your thoughts about this. That is signaling that this is the beginning of a discussion with both sides. And unfortunately for us, Paul does not attach more transcript here to show how that conversation went, what the attorneys said on either side, or what the judge said at the end of it. So for our purposes, there's this really big question mark as to where the topic settled at the end of this hearing. But the reason I personally doubt that the judge ended up feeling just as concerned at the end of all of this is, again, he didn't say anything about this in his formal written order that followed up this hearing, and he totally could have if he had wanted to. If he was still concerned, he likely would have reminded the parties about that concern in that written order. However, although we can't be sure from this vantage point that you and I are sitting in, the judge obviously was there for the hearing, and he most likely remembers why he was concerned and what he said and how he felt at the end of this hearing. And in my experience, judges don't often take too kindly when they think that one party is taking something that he or she said before and then twisting that into something different. And that can result in a verbal lashing from the judge in response, or it can also just mean that over time, the judge starts to build this feeling of disdain or annoyance or mistrust against your side. Remember, judges are human too, and they develop a sense over time about the attorneys that are in front of them. Who's professional, who's honest, and who's maybe not so much. And throughout litigation, there are many decisions along the way where the judge has to use his or her discretion. And sometimes if the judge thinks that you have a pattern of being dishonest or unfair, or that you often engage in dirty litigation tactics, that can leave a subtle impression that can make a difference later on down the line when it really matters, when the judge is making one of these discretionary decisions. And so, if I'm reading this correctly, I think that Paul's lawyers might be running the risk of creating a negative impression with the judge at the very least. And that ultimately can, of course.
The footage cuts abruptly. The legal arguments and the ultimate ruling remain hidden from view, leaving the courtroom outcome entirely to speculation. Logan Paul maintained a calculated strategy throughout the proceedings, signaling a desperate need to keep those deposition tapes private. Following a lengthy period of total silence, confirmation surfaced that the entire matter reached a conclusion through an out-of-court settlement.
After years of drawn-out civil litigation that's undoubtedly cost millions of dollars, Logan Paul and Coffeezilla recently quietly settled out of court.
Decades of filings and millions spent on legal fees culminated in a confidential settlement reached behind closed doors, without a trial ever occurring. The contested deposition never entered the public record, leaving Logan's sworn testimony sealed. The settlement details remain undisclosed, so the exact contributions are unknown. Yet the financial aspect was never the true focus of the dispute.
What did each side actually need in order to quote-unquote win? Coffeezilla walked in with the public already on his side. He did not need to sway anybody with new evidence. Instead, what he needed to do was survive this lawsuit without going bankrupt. But then we look at Logan Paul. He needed public opinion to flip. That's where he was actually impacted in this whole saga, and the settlement money alone wouldn't fix that. I mean, remember, this is a self-described petty billionaire. Whether Coffeezilla paid him $0 or millions of dollars, that money changes nothing about Logan Paul's life because it's essentially probably a drop in the bucket. So arguably the only way that any settlement amount really means anything to Paul personally is how much his ego thinks it hurts Coffeezilla. And the thing is, we know Paul cared very much about hurting Coffeezilla financially through this lawsuit because he texted as much with his buddies.
Legal Bites noted that it is unclear whether Coffeezilla emerged financially whole, but the key indicator remains his continued video production and crypto coverage without interruption. If the objective was to bankrupt him into silence, the strategy failed. Ultimately, the lawsuit backfired on Logan, who sued to prevent the scammer label. The legal action placed the term scammer alongside his name in filings, news stories, and court records for 2 years, drawing far more attention to the CryptoZoo controversy than Coffeezilla's video could have achieved.
And in this case, I have to be blunt, that vindication never came. There's absolutely nothing from discovery or any of the arguments in court papers or any other part of this litigation that moved the public towards Paul. If anything, his reputation actually got worse through the course of this litigation.
The settlement serves as definitive evidence. He held the power to expose these videos as fabrications before a jury, yet he chose to retreat. Although the legal system reached no formal verdict, the choice to abandon the case when holding a winning hand revealed everything onlookers needed to know.
When a plaintiff doesn't really care about the money because the amount isn't really going to make that much of a difference in their life, a settlement really only means something if it comes with something more. That might be something like a public apology, or like the defendant saying, I lied, or at the very least saying, I shouldn't have said what I said. But the thing is, there seems to be zero evidence of anything like that going on here. So this is what all of this adds up to. Logan Paul spent millions of dollars on an inflated legal team to change the public narrative about his dealings with CryptoZoo, and for all that cash spent, nothing changed. He effectively burned all that cash for absolutely nothing. In short, this lawsuit was a big fat failure for Logan Paul.
The remaining evidence tells the whole story. The videos still carry scam in their titles, and none have been retracted or edited. The deposition remains hidden, leaving the sworn testimony unknown. The CryptoZoo class action continues, so the investors who lost money remain stuck where they were 3 years ago, while the mastermind has spent his resources on legal fees. That is the true scoreboard, unrelated to any payment exchanges. Logan's settlement reflects either a decision to move on or an acknowledgement that prolonging the fight would only damage his reputation further. Share your perspective in the comments, like the video, and subscribe for the next installment.